Welcome to Team Tiggio Court TV, where we upload videos every single day. So make sure you subscribe to our channel, like our videos, and share our videos.
7AL, Counsel, you want to state your appearances, beginning with petitioner?
Christy Van Massenholt on behalf of the petitioner, Jacob Beauvais, and Mr. Beauvais sitting to my right.
Jeremiah Buffalo Worgo on behalf of the state.
All right, and Ms. Van Massenholt, this is your motion for a review of the denial of Mr. Beauvais's petition to reinstate his driver's license after a revocation for some drunk drivings. Go ahead with any argument.
Thank you, Your Honor. We're here today to have the decision, the February 14th, 2025 decision reevaluated. There was a revocation of my client's driving privileges under MCL 257.3034. This appeal rise pursuant to MCL 257.323. The record before the court is clear. Mr. Beauvais has maintained continuous abstinence from drugs and alcohol since September 8th, 2021, verified by consistent negative drug testing under parole supervision and while incarcerated with MDOC. He has engaged in counseling, completed treatment while incarcerated and while he was on parole. He submitted corroborating letters attesting to his stability, lifestyle changes, and sustained sobriety. Despite this evidence, the hearings officer denied relief based on 3 grounds. Number 1, that his sobriety while on parole did not demonstrate he could remain abstinent in the quote free world. Number 2, that his substance use evaluation was incomplete or unreliable. And number 3, that his support letters were insufficient because they did not represent a broad quote cross-section of the community. Respectfully, each ground rests on legal error and findings unsupported by competent material and substantial evidence.
Can you address particularly, so I frankly agree with you about the supervision aspect. I've encountered this in other cases where the Department of State discounts periods of recovery or sobriety while somebody's on probation or parole. I don't find that to be a persuasive grounds to deny them that relief. That's why we've got probation and parole. You know, we have too few success stories with supervision as it is, and I don't think we want to discount when we do have success. But I'm interested about the substance abuse evaluation because it looked to me as though there was some underreporting in the evaluation process of Mr. Beauvais's prior record, and why wouldn't that be grounds to deny it?
Yes, Your Honor. When I read the order and I saw that there was an allegation that he underreported, I went through that substance use evaluation and I had my client's conviction record next to it. And what I found is he absolutely accurately reported his offenses that related to alcohol or substance use. And the form itself, from the department's own form, asks for all driving and non-driving convictions involving, and the key word is involving, alcohol and drugs. And that is exactly what my client reported. He has other convictions, but that question did not require disclosure. However, he did disclose it to the evaluator. He testified to that in the hearing, but then also in the explain your prognosis in detail, it outlines some of my client's convictions that weren't of the best judgment. He addressed those. And so therefore, how can he be found to be not totally forthcoming if he answered the question honestly and accurately, and then he further disclosed how his convictions had led to, you know, his relapse years ago and incarceration again?
Do you know which convictions the hearing officer is referring to that were not listed on the substance abuse evaluation form?
So see, that's the interesting thing is because she never cites which ones. So I looked and again, I confirmed.
Well, I guess let me ask that a different way. What convictions does your client have that are not already listed on that form? On the form is the 2002 DUI and open intoxicant,
Yes,
the 2005 OWI,
yes.
and the 2021 possession. What other offenses does he have?
Retail fraud, Your Honor. Retail fraud. And there was also resisting an officer.
Okay, go ahead.
So yeah, absolutely. Again, and I don't mean to beat a dead horse with that. He disclosed what was asked of him, but he did. And I guess I'd like to also bring up that we went through his criminal history in the office, in the hearing. We went offense by offense, what his life was like at that point, and why he's a different and changed person now. So had that been a concern for her, Rule 257.313 allows that meaningful opportunity to correct or supplement a record. That was not provided, and my client could have absolutely explained in more detail if the hearings officer would have liked clarification of maybe an affidavit under oath that he did in fact talk to the substance use evaluator about all of his criminal history.
So even though this is a review on the record, just to satisfy my curiosity, has your client been discharged successfully from parole at this point?
Yes, Your Honor.
When?
April 2nd of 2025.
Okay.
And he still maintains his counseling, and that was discussed in the record that he satisfied the term of parole, that he had to complete it, but he continued after even successfully completing the term that they wanted to counseling. He continued to this day, and he still drug tests to this day.
Okay, anything else you want me to know to understand your position?
Thank you, Your Honor. I do want to address the cross-section of the community. That was especially offensive to me. And this is why. My client made the conscious decision that he cannot associate with his prior friends, his prior peers, because they do not provide the stability and frankly, for his sobriety. So he had to cut a lot of people out of his life. Who is left? His family and his coworkers and individuals he's met while he was incarcerated. Sarah Prevost, who helped him get facilitated for school. She had a lot of contact with him, and she wrote in her letter how hard working he is, how dedicated he was to that. And the reason that was so important is when you're sober, you have to work every day at that. And that letter showed that he has the fortitude to continue to work on his sobriety. And then his mom provided a letter, and she provided it from a non-biased, just observing who the individual who was petitioning, her son, who he is as an individual. But yet, because it was his mother, that letter was totally discredited, which is frankly really offensive, because the best person to assess his sobriety is his mom, because they live together. She's the one who provides the transportation. We live in a small community. He isn't able to call public transportation very easily to get to and from his work.
Well, that might have been, I mean, just, I don't know, just a bit of a discount because I don't know if I'm speaking too much out of turn. I think this is just general life experience that Not too many dads would lie for their kid, but almost every mom would. So maybe there was just a discount because it's a letter from his mom. But go ahead.
Maybe, and and this on that is my client, and this was testified to in the record.
I don't mean that as a disparagement on the honesty of mothers. I have to clarify. I just mean that as that mothers love their children in a different way than fathers seem to.
My client maintained his sobriety because his father passed away, and my client maintained his sobriety during that time period. He was there with his father, helping him in his end days, was sober the entire time. So that speaks to his commitment and showing that he can have really hard life situations affect him and still stay sober. And so when you don't have the friends, and because of his conviction and his prior record, the jobs he's able to apply to are more on the limited side. So he felt his coworkers aren't individuals that he can socialize with outside of work to maintain his sobriety. And where does that leave us? With the best cross-section we can have of letters. We're not picking a jury. We're picking people who can attest to his sobriety.
All right, thank you. Mr. Wergo, Secretary's position.
Your Honor, I didn't have the benefit of having the order to review. It must have got lost in the shuffle. But in reviewing the transcript and the record that I do have, seems like I had the same concerns that the hearing officer did, though maybe I would word them a little different, other than I would agree that the cross section relative to Mr. Bovis's history, kind of, he's not likely to have a long track record of employment given everything. I think that the petitioner might be on point with that. As to the substance abuse assessment, that is a bit concerning, Your Honor. Even if they are not germane to the nature of the application, it is something that in counseling one would think should be disclosed. And as to an ability to supplement the record, yes, that exists, but not an ability to go back in time and redo the things that we're supposed to do in order to show the burden that a petitioner has here. But most telling, Your Honor, I think I would reword it. I would word it differently than the hearing officer, but we just don't have enough time of sobriety, and the transcript is rife with very honest and forthright testimony that it appeared Mr. Bovis gave relative to his issues that got him in the situation in the first place and how extreme his dependence was. I think when weighing that against the length of time that he's been sober, which I don't doubt, I think he's doing a great job. I just don't think that it's been long enough, Your Honor, and I think that is the true heart of what the hearing officer was very likely to get at. Now, the standard isn't what would I have done in the situation where that might be a closer call. The standard is, was there clearly an abuse? And I just don't think we have it, Your Honor. Thank you.
Thank you, Mr. Mason. Nobody rebuttal argument? Yes,
Your Honor. My client has been sober for 3.5 years. That is actually 3.5 years as of the time of the hearing. We are 1 month away, 2 months away from having 4 years of sobriety. And just as what Mr. Wergo was saying, that my client testified honestly. He absolutely did testify honestly. And you can't cherry pick what was honest and what was not. So if he was honest about his struggles, then, and it was honest testimony, then you have to extrapolate that and say he was honest about his successes as well. And this isn't an opportunity to correct the record or submit additional information, because it was a great packet. It had letters from his counselor every time he went. And the part that I'm really struggling with is how can he be held that he didn't disclose convictions if he followed the form and he answered each question on the form. He can't be penalized for doing exactly what was told of him. Plus, he did disclose all of his convictions. It was during the conversation with his counselor, which he wrote the letters, and then also in the substance use evaluation. And if he has 3.5 years of sobriety, and there's competent documentation to show that he did, maintain his sobriety, then he should be given the chance to show that he's able to have the privilege of driving.
Can you agree that the statute has some time ago been amended where I can direct the secretary to issue a restricted license with the interline?
Yes, Your Honor.
All right. Well, that's what I'm going to do. I'm going to find that there was a clear abuse of discretion and that the hearing officer's decision was not supported by competent material evidence on the whole record. The the evidence did show that the petitioner met his burden of proving by clear and convincing evidence that he had more than 12 months of abstinence and his substance abuse problems were under control and were likely to remain under control. The hearing officer denied the petition for 3 reasons. First, that his sobriety and abstinence was achieved while he was on supervision. As I've outlined, I don't see any reason in fact or in law to discount somebody's efforts just because they're on supervision. I've seen that time and again from the Department of State hearing officers. I frankly do not understand it. If being on supervision, they seem to have this pie in the sky view of being on probation or parole as if, gee, if I get in trouble, if I use, I won't use. Well, you know, I honestly wish that's how it worked, but it doesn't work that way. People use all the time when they're on probation and parole. We get all sorts of violations and new criminal offenses while people are on probation and parole. It just doesn't work that way. What works is when people are honest with themselves and put in the effort to get into recovery. And whether they do that on supervision or off supervision, it's the same work. So to discount that is not warranted in fact or in law. Also, the letters, the hearing officer found that those were insufficient. Again, this is something I routinely see from the hearing officers that, again, I think is just a preposterous way that they approach this. One of the key components to being in recovery is to change all your people, places, things. And then they say, well, your letters don't have somebody that says the last time they saw you use drugs. Well, guess what? Because you don't need that person in your life anymore. So the letters did corroborate and give substantiation to the petitioner's own testimony about his recovery. That's the purpose of the letters. It's not to say, you know, I got to find the guy that I last tied off with, and he's got to talk about the last time I used and what I do now and that I don't use. That's ridiculous. The one that I thought was troubling to me was the substance abuse evaluation. The hearing officer's stated reason for denial was that the substance abuse evaluation can't be relied upon because it was too optimistic in its prognosis, because the evaluator didn't know the extent of Mr. Bovace's alcohol and drug-related criminal history. And at first I thought that was going to be grounds to deny the appeal today, but as Ms. Van Massenhoek points out, the conviction history says to list all driving and non-driving offenses involving alcohol or controlled substances. I may read that, and the hearing officer clearly read it to mean if I have an R&O and I was drunk at the time, I should list that. If I have a financial transaction device conviction and I was using at the time, I should list that. I might think it includes that because that did involve your use of drugs or alcohol. But it's an entirely fair reading to say, no, I'm going to list all my alcohol and drug convictions. And a theft conviction is not one of those two things. An R&O conviction is not one of those two things. And so there's no drug or alcohol convictions that the petitioner left off of the conviction history. And, you know, so he reasonably followed the instructions that were given. And, you know, I think for a hearing officer to say, well, you had a couple drunk drivings and possession of drugs, but you're sober now, you have been for 4 years or for 3 years, and your prognosis is good. I'm just not sure it's realistic to say if they knew, oh, but you shoplifted while you were high once. Well, then it's no good. I mean, I don't know that would change the analysis so completely. So I think on the on a careful review of this record, I agree with the petitioner that the hearing officer's decision was not well founded. So I would, however, given his relapse history, not direct the secretary to give him a full unrestricted license, but to issue a restricted license with the interlock. And so, Ms. Van Massenholt, you can present an order to that effect on the scale of forms. The Secretary of State's office really likes to see the prosecutor having approved it as to form. So if you can review that with Mr. Burgo before you submit a report, that'd
Absolutely.
be great. All right,
Thank you so
very
much, Your Honor.
Good day.